Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everybody. It's Tuesday morning, and we're here again, Rick Moscoso and myself, Bill Bernard, for another Bottled Business Sense show. And as you probably know by now, all of our listeners and viewers, we provide this show for free, and we do it to help business owners and entrepreneurs be successful, both in terms of protecting their business and making it prosperous so it can move forward and be the kind of business that the entrepreneur wanted it to be from the day he or she started it. And this show involves a variety of legal topics and marketing topics from time to time that really is geared toward, but of course, you know, it depends on the business owner to put these things into operation and to make sure that they take these tips seriously and adapt it to their own specific situation. Whenever we give legal tips on the show, we urge you to talk to your own lawyer to make sure that while you employ any of our tips, they are apropos for your specific situation. Having said all of that, we can be found on all kinds of social media, on Facebook, on Twitter, on LinkedIn, at bottlebusinessshow.com, where you can view our shows at your leisure. You can download shows, audio shows at Blog Talk Radio, where you can look up our show, Bottled Business Sense. And I do this show, of course, as I said, with Rick Moscoso, my co-founder and co-host, and he's raring and ready to go today for today's topic. And let me welcome him in. Rick, what's cooking this morning, man? How are you?
I'm doing great, Bill. It's a beautiful morning here in Southern California. It's nice and cool, and I am excited to hear about the episode that you're going to talk about, because you know some people, when they look into developing or creating a trust with the help of their attorney, a lot of times they wonder where are we getting all this stuff from? How do we put it all together? And so I know you're going to go over that with us today, and I know, just like anything else that we do in business, things need to be fluid. Things change all the time. You have to be adaptable, and you have to have systems in place that can take advantage of or position you in the right manner so you can act accordingly, especially when things change and situations change. So I am very interested in sharing this information with our viewership today. And today, Bill's going to talk about understanding the funding of your living trust. And so why don't you just, what do we have on cooking in regards to that topic?
Well, look, changing your trust or maintaining your trust is like changing the oil in your car, or if you have a business, making sure your profits are up from one year versus last year. You've got to make it be progressive, and you got to make sure it's up to date, right? So in order to do that, sometimes you have to take things out of your trust and put things in your trust. But before we even get to that point, I wanted to talk a little bit about today what is funding your trust? What does it mean? how do you go about doing that, and what effect can it have on your living trust if you don't fund it properly? I mean, this is really important stuff, because a lot of people think, well, they get a living trust and everything is taken care of, and it's and they're rip-roaring ready to go, and that's not the case. Let's start by talking a little bit about the fact that funding your trust is the process of transferring your assets from you to your trust. Okay? To do this, you physically change the titles of your assets to the name of your living trust. So if you have the Rick Moscoso Living Trust, it is, whatever date you execute it, you're going to want to change your title of property that you put into the trust into the name of that trust, which is the Living Trust of Rick Moscoso, dated blah, 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 right? If you've signed your living trust document but haven't changed titles and haven't changed beneficiary designations, you will not avoid probate. You'll have a living trust and you'll still have to go through probate because it's not funded. Title hasn't been changed. Your trust can only control assets, ladies and gentlemen, that you put into it. You may have a great trust, but until you fund it, that is, transfer your assets to it by changing title, it doesn't control anything. It's not worth the paper it's printed on. Now, ideally, you would think, right, Rick, that your attorney should review each asset with you, explain the procedure, and help you decide who will be responsible for transferring each asset. And that's what should happen, because once you understand the process, you can decide to transfer as many of your assets as you want by yourself, or you can have your attorney's help. For example, when I do my trusts, I'll provide a deed to the property of the people who now have the trust, and I'll provide that to them, and then they go down to the courthouse and file that new deed. Now, that's kind of a hybrid, you would say, right? Because I don't actually file the deed for them, but I prepare it for them, and then they go down and pay the fee and file it. Some attorneys will have you just prepare your own deed or go down and file it at the courthouse yourself. It just depends, but either way, you need to touch base with your attorney to make sure of what? To make sure you know what's supposed to go in your trust and what's supposed to not go in your trust. This is not a difficult process. It doesn't, but it will take some time, because living trusts are so widely used nowadays, folks, that you should meet with little or no resistance when you transfer those assets. But it will take a little bit of time to do. It's not something that I said is going to happen automatically. Yeah, Rick.
So wouldn't it make sense then, and maybe I'm not understanding everything in regards to what goes in a trust, but wouldn't it make sense to say, this is my opinion, and I don't know, but any assets that you own, wouldn't that make sense to put into the trust?
Well, we're going to talk about that. Not any assets. It depends on how you define assets, right? I define assets as probably a little more widely than some people. I believe it's anything that has value. A little bit about that. But before we do, let me just remind everybody as well that when you're transferring these assets that we're going to mention, some institutions will want to see proof that your trust exists to satisfy them. It's not all you're going to need is have your attorney prepare what's called a certificate of trust. That's a shortened version of your trust that simply verifies that your trust exists. It explains the powers given to the trustees and identifies the trustees of your trust, but it doesn't reveal any of your personal information about your assets or your beneficiaries or any of the inheritances that your beneficiaries are going to get. So understand, right? Because one of the reasons why we create a trust is to what? Not only to avoid probate, but to what? To have privacy. It's all private, right? Because once you have probate without a trust, then it's all a matter of public record. It's court record now. Anybody can look it up. Anybody can find out what it is. So the certificate of trust allows institutions to know you have a trust without looking at the specifics or the substance of the trust. So I would suggest when you're going through this process to make this transfer, you make a list of your assets, what their value is, and their locations. Start with the most valuable ones and work your way down is the way I would suggest to do it. So having said that, we want to also remind everybody that let's say you refinance, you're in the middle of refinancing your property. And we're going to acknowledge part of Rick's question here right now, that your property is going to be one of the things you're going to want to put into your trust, right? Your real property. Refinancing may not be easy at all times because a lot of lending institutions require that you transfer the property back to your personal name before you refinance. They don't want to refinance while it's in a trust. So you take your property, if you put it in a trust, you merely file a quick claim deed down at the courthouse to take it back out of the trust and put it in your personal name. You do the refinancing and then you put it back into the trust with another quick claim deed. Because your living trust is revocable in this situation, we're not talking specifically about an irrevocable trust. Because it's revocable, transferring real estate to your trust should not disturb your current mortgage in any way. In other words, some of these mortgages have due on sale clauses, right? So if you get a refinance or you get a loan on your property and then you want to put it into your trust, the due on sale clause is not going to come into play, even though you're changing title to your trust, because we make provisions to be able to put property in trusts. So you also need to remember that you shouldn't fear about a property tax increase, because placing property in your trust is not going to cause a property reassessment. Okay, so having your home in your trust, that we're going to address with regard to Rick's question, that would have no effect on reassessment of your property, due on sale clauses for loans, and it will not affect your capital gains tax exemption that you would have as a married couple, for example, or as a single individual. Right, $250,000 if single, $500,000 if married. It's not going to affect that just because you're changing title and putting it in the name of your trust, as opposed to changing title and putting it into the name of another individual, which would cause these things to occur. Okay, so
if somebody was in the process of if somebody was in the process of refinancing, would you recommend that they wait to proceed with the trust until the refinancing is done, or just go ahead with the trust and then go through all the?
Well, if they haven't put it in the trust, here's what I would do. I'd probably tell them to wait, but it wouldn't hurt to ask the banking institution what their policy is. And if they say go ahead and put it in the trust anyway, do it. But most often than not, if they start the refinancing process, it's going to be started already in the application that you filled out. And so if the application was filled out in your name, you're going to want to wait and put it into the trust after the financing takes place. Now let's talk a little bit, Rick, about community property, because that comes into play when you're funding your trust. Community property can be continued inside your living trust. So if you live in a community property state like California, your attorney may suggest that jointly owned assets, especially real estate, be retitled as community property before they're put into your living trust. Why? Reduce your capital gains tax if the asset is sold after one spouse dies, right? Because you get a $500,000 capital gains exemption. So you're going to want to make sure it's titled in community property status, so that if one spouse dies, that's the remaining spouse can take advantage of that tax exemption. But remember, this depends on the size of your estate, right? Because federal estate taxes come into play. $5.4 million, I believe the exemption is currently. So if you're going to have an estate that's got a tremendous value, federal estate taxes must be paid if the net value of your estate when you die is more than the amount of the exemption. So if your estate will be subject to estate taxes, or if you anticipate that it might be, you might want to set up a irrevocable trust for your life insurance proceeds. So again, back to your question, Rick, what do we put in the trust? Well, we already determined the house is one thing. Do you put your life insurance in the trust? You could put your life insurance in the trust and make the trust your beneficiary of your life insurance policy so that all of your beneficiaries share in the life insurance proceeds when you pass. But if that's going to increase the value of your estate to over $5 million or so, and you'll have to pay estate taxes when you die, then you may want to place it in an irrevocable separate life insurance trust, because that will bring down the value of your estate and will allow that life insurance policy to be subtracted from the value of your estate and not be subject to the estate tax. So you have a separate irrevocable trust for your life insurance proceeds. You have a revocable trust for the rest of your assets. If your life insurance proceeds is going to be smaller and not put you above the $5 million mark for estate tax purposes, you may want to go ahead and include that life insurance policy in your regular revocable trust and have it dispersed between your beneficiaries. Remember, one of the things you must consider, folks, is whether you want this life insurance policy to go to one person or have it shared by beneficiaries in your trust. If you want it to go to one person, there really isn't any need in a lot of instances to just go ahead and put it in your trust. Just let it go to this one individual, unless again you're trying to reduce the value of your estate somewhat, and you want to go for an irrevocable trust anyway. A lot of options here. This is why I say talk to an attorney. Funding your trust is pretty simplistic once you know what goes in it. But sometimes you want to determine circumstances what should go in it and what shouldn't. That's the more difficult process. The easy part is once you've determined what goes in it, it's pretty easy to make the switch and then go ahead and then physically fund it. Okay, so those are the things we're talking about. I know a lot of people have asked about cars, Rick. Would you think you put a car in your trust?
Well, I guess if it's an investment car, like a valuable car, you may want to consider it. No.
Excellent answer. Yeah, let's say it's a collector's automobile. You might want to put it in your trust, but unless the car has value and substantially increases your estate, you probably don't want to put it in your trust. If it doesn't have the value and does not increase your estate, or does increase your estate, either way, I wouldn't put it in. Here's why. The reason is if you're at fault in an automobile accident and the injured party sees that your car is in a trust, they may be more apt to sue you because they tend to think, hey, this guy's got a trust. They must have some deep pockets. Right? Because remember, the items in your revocable trust, items in your revocable trust, not irrevocable, but revocable, are not protected as part of your asset protection. Those are susceptible, even though they're in the name of the trust and not in your personal name any longer. They can be reached if somebody sues you. That's why we have irrevocable trusts as a part of our asset protection program. Revocable trusts do not provide clear-cut asset protection. So, having said that, all states, including California, do provide for affidavits that you fill out so you can transfer a car to another person once the person who owns the car dies. So unless this car is really valuable, and unless it will still not increase the part of your estate to put it over the $5 million mark or so, I don't see any reason to put it in your trust. What about IRAs? Should you fund your trust with an IRA? Well, you can name your trust as the beneficiary and share your IRA between everybody, right? But be sure you consider all your options, which include your spouse, children, grandchildren, charities, because who you name as a beneficiary will determine the amount of the tax-deferred growth that can continue in your IRA, right? Here's what I mean. Most married couples name their spouse as a beneficiary of their IRA, right? Mm-hmm. The money will be available to provide for the surviving spouse. Well, the spouse can take advantage of a rollover provision in the IRA and continue that IRA from the deceased spouse and continue to have tax-deferred gains in that IRA And then that spouse can name a new beneficiary when she takes it over or he takes it over, such as your child or your grandchild. So Ralph, Rick, God forbid you pass, your wife can roll over your IRA, still take advantage of the tax-deferred growth because it wasn't put in your trust. And now she can name your son or your daughters as new beneficiaries for when she passes. Again, no real need to put your IRA in the trust unless you want it to split between everybody who's your beneficiaries, who are the beneficiaries that are named in your trust. So I thought the best way to just synopsize this or end the show, Rick, would be to kind of do a little a summary. And remember, what I'm about to tell you is a summary of assets you may want to put in your trust and a summary of assets that you don't want to put in your trust. All of these assets have value. And based on our discussion here today, you may want to consider whether you want to do it or not. The ones that for sure you'd want to put in would be real property, right? Home, land, other real estate. Unless it's changed into the name of the trust, your trust is not funded, and therefore it is meaningless. You paid for a living trust for nothing. Number 2, bank or credit union accounts, right? You're going to want to put your bank accounts, rename them in the name of your trust. Number 3, your investments, CD accounts, stock accounts, mutual funds, your Edward Jones accounts, your Merrill Lynch accounts, whatever you have. Change them into the name of your trust. Number 4, any notes that are payable to you. Somebody owes you money, personal loans. You want to put it in the name of the trust. Number 5, life insurance policies, perhaps based on the discussion we just had, or you may want to establish a separate life insurance irrevocable trust, right? Number 6, business interests and any intellectual property you own, inventions, or your business itself. Captivate 365, LLC, you want to put that in your trust. The interest in your business will go to your heirs. Let's see, what are we on? 1, 2, 3, 4, 5, 6, 7 would be oil and gas interests, if you have any of those. And number 8 would be your personal property that is untitled. Remember, your car is personal property, but it's titled, right? And unless it's valuable, you don't want to put it in your trust. But any untitled personal property, you have a personal property list. Your valuable paintings or any rings or jewelry or things like that you want to leave somebody. So that's a real short, good, concise list of 8 major areas of that you want to use to fund your trust. What you don't want to put in your trust, ladies and gentlemen, would be IRAs or other tax-deferred retirement accounts, unless you want to spread it out between all your heirs. Incentive stock options, and of course, life insurance policies, as we discussed earlier, unless you want to spread that out among all your beneficiaries. And of course, your motor vehicles that are titled, unless it's a very valuable motor vehicle. So keep this in mind, because funding your trust is what, Rick? The process of transferring your assets to your trust. You must physically do this, because if you don't do it, your trust has no meaning. It has no force and effect. And you've basically spent your money, which was supposed to be a good investment. You've spent it for nothing if you don't take the assets and transfer them into your trust. So what's the first thing you're going to do when you get a trust, Rick?
Well, you got to itemize it first to take a look if it's even worth formulating a trust. Go over that with an attorney and itemize the items that you are potentially going to put into the trust, right? I mean, first thing I would do is I'd call somebody like you, right, to figure out.
That's right. But let's touch on an item you just mentioned.
Yeah. You
should always have an estate plan. I don't believe there's an instance when you shouldn't have an estate plan. I mean, unless you have an estate that's got nothing but a value of $150,000 or less, where you can use a short form affidavit and avoid probate, I would have an estate plan. So that's the first thing I want to mention. Second thing is, Rick's correct. You sit down with a lawyer, you map out your valuable assets, what goes in the trust, what doesn't, and then you go ahead and you make the transfer by deciding which, if any, will be transferred into the trust by your lawyer versus which you can do yourself. And of course, the more you can do yourself, the more what? The more legal fees you save. Mm-hmm. So I hope everybody's gotten a clear picture of what funding your trust is, why it's so important, what items do go in and what items don't go in your trust, and finally, how you physically go about doing it. Use that certificate of trust. That's a part of your trust documentation that I create when I do a trust for people. And when I do a trust, I do the living wills, I do the health care information, I do the certificate of trust, the powers of attorney, the whole ball of wax. And Rick will be coming out with a new website here next week for me. protectyourestate365.com. And when you see it, I think you're going to be pleasantly surprised, both in terms of what you can accomplish for your family and what the minimum cost will be for allowing you to do so. Right, Rick?
Yeah, absolutely. I mean, and folks, if you go there now, you will see the existing site. But as soon as we turn that over and wrap up a few last items on that site, you will see the customized brand new site for Protect Your Estate 365 that Bill has fine-tuned and developed, especially for the user out there, to help you step through some of these initial questions that you may have. So it's going to be very thorough. It's going to be very user oriented. To get you started, but most of all, it's going to be simple and it's going to be very complete. So if you have any questions in regards to this, we'll make an announcement here, both on the website and also on the show once that's up and running. But in the meantime, if you do have any questions in regards to a living trust or the topics that we talked about, please reach out to Bill. His information here is below.
Yep. Well, with that, everybody, we're going to sign off for this Tuesday and invite you to please come back and join us next Tuesday. We're on the air every Tuesday morning at 10 a.m. And generally, our shows run between 20 to 40 minutes, depending on the length of the topic. But again, we're here to provide you with free information to keep your business in that bottle that's protected and floating along and continuing to be prosperous. And again, as Rick and I have said many times, that's what we enjoy doing. So until then, have a prosperous week and take care. And we'll see you here next week.
All right. Have a good day, everyone. We'll see you again next week.